For today's story, we are covering the latest ongoing drama from Without a Crystal Ball as it relates to the lawsuit from Chrisley Knows Best. Chrisley doesn't know best in this lawsuit. We're going to find out why. Let's get started. Hi everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you enjoy this legal educational content, I hope today may be the day I earn your subscription. For today's coverage, yes, it is our friend Katie Joy Paulson, who once again is being sued by someone who has no clue. In this case, the case of Michael Todd Chrisley. Michael Todd Chrisley is a famous star, has a TV show, Chrisley Knows Best, and has some problems with his daughter, namely that he was accused of trying to threaten his daughter that he would expose a sex tape of her if she didn't cooperate in regards to an ongoing legal proceeding. How exciting and fun. And Katie Joy Paulson has reported on this. The plaintiff, Michael Todd Chrisley, is a national television personality. Their daughter, Lindsay Chrisley, has publicly reported that Chrisley threatened to release a sex tape involving her alongside nude photos of her. She discussed this threat on national television and subsequently has discussed it with multiple media sources. Yes, she went on Dr. Phil and she mentioned this, that her own father apparently threatened to expose a sex tape of her if they didn't cooperate. So that's kind of creepy. The defendant, Katie Joy Paulson, who is here apparently known by her maiden name, is a journalist focusing on celebrity news and entertainment stories. Paulson is far from the only journalist to cover this story, but she's the only journalist Chrisley has sued over her coverage of Lindsay Chrisley's victim statement, discussion of the same on national television, the possible reasons for the threat, and potential ramifications. Okay, a couple items of note. First of all, is Katie Joy Paulson a journalist? And the answer to that question is, yeah, probably, because the word journalist doesn't have a protected meaning because it's a First Amendment interest, right? You're a journalist if you say you are, pretty much. And she's an opinion person, but there are opinion journalists. And she offers biased views, so, she can float from status to status, as one might do, when they're offering commentary. So, is she a journalist to the extent that she's providing truthful information and reporting on it? Sure, why not? She doesn't need any special criteria to be a journalist, so she calls herself a journalist, so she is. And whether she calls herself a journalist or not, she has the same duties anyone else does. She has a duty to tell the truth, not lie. She has a duty to make opinion and make fact, and, not defame people. So, sure, why not? And she apparently is the only one being sued by Chrisley, even though other people are reporting on the same thing. Okay. So in case I didn't make it plain before, by the way, this is Katie Joy Paulson's response. So this is in her voice. So this is what she says about herself. She's a resident of Minnesota and nationally known entertainment and celebrity journalist. Yeah. She regularly cited and reported on herself in national publications such as People Magazine, In Touch Weekly, Today Show, US Weekly, and more. I believe that's mostly true, that she has gone around and being reported on. She does have some following. She has a YouTube channel with 186,000 subs. That's way too many subs because it's more than 4 times as many as I have. So, we gotta work on that. On August the 13th of 2019, Chrisley and his wife were indicted by the federal government on 10 counts of attempting and conspiracy to commit fraud, bank fraud, fraud by wire, conspiracy to defraud the United States, and attempt to defeat taxes. So being charged with all kinds of financial crimes. In the response to the criminal case, Chrisley filed a civil suit against Joshua Waits, the director of the Office of Special Investigations for Georgia Department of Revenue. So he's suing the tax man, alleging, among other things, improper dissemination of tax records and tax return information to Chrisley's daughter, Lindsay Chrisley. So part of the allegation here, and suing the tax commissioner, and good luck with that, is that the tax commissioner gave tax information to the daughter when he's not supposed to have it. I mean, tax records are supposed to be confidential. So if that's true, that probably poses a problem unless there's some reason for her to know it because she is in some way included in the tax returns. But, you need to know more. Chrisley admits in his complaint, that's his legal filing, that his daughter, Lindsay, gave a nationally televised interview on the talk show Dr. Phil, recounting her own experience of being threatened by her father with exposure of a sex tape on which she was featured, as well as nude photos if she did not provide testimony in the criminal case, stating she had an affair with a state official for the purposes of influencing the investigation against Chrisley. This interview is still freely available. So I don't know who the sex tape is with, although one would infer from context that it might be with someone from the Department of Revenue, which might also lead credence to the idea of improper sharing of information. But yeah, apparently Mr. Chrisley, the father over here, threatened his own daughter with revenge porn if she didn't conform testimony, which I'd like to remind everyone, revenge porn is very illegal. So, there's that. So don't do that. In response to this meeting with Dr. Phil, Lindsay also filed a police report with the Cherokee County Sheriff's Office. The police report addresses terroristic threats and records Lindsay. The police report addresses terroristic threats and records Lindsay Chrisley's narrative in part as following. Upon speaking to Lindsay, she stated there's an ongoing issue with her family threatening and harassing her. Lindsay stated recently she learned her stepbrother, who lives out of state, claimed to have purchased a sex tape involving Lindsay. So it's her stepbrother who bought it. Lindsay stated her father and stepbrother wanted her to lie about the incident, and if she refused to do so, was going to release the sex tape. So what are you doing, stepbrother? The answer turns out to be buying a sex tape that I'm going to use to blackmail you with. How exciting. Okay, so let's discuss the legal standards that are in play and whether or not Katie Joy Paulson can be sued by Chrisley. By the way, the answer is no, but we're going to go ahead and discuss the legal standards anyway, so let's do that. Pleadings that fail to state a claim upon which relief can be granted must be dismissed. When determining whether a motion to dismiss should be granted, the court takes the facts alleged in the complaint as true. On a motion to dismiss for failure to state a claim, the district court may consider only the complaint and the documents referred to in the complaint. So this was also an issue when we were talking about Toddy and Without a Crystal Ball way back when, remember? That you can only consider the complaint and the documents referred to by the complaint, not other stuff. So yeah, that's the law here too. A complaint must provide more than mere labels and conclusions. A claim is sufficient against a motion to dismiss for failure to state a claim if it's possible on any evidence that might be produced consistent with the theory to grant relief. So is there any evidence at all, that would show that they did a bad thing? Okay. In this case, the plaintiff cannot rely on the common law formulations of defamation or the Minnesota Supreme Court holding in this other case called Stumpgas, because Stumpgas did not address the application on principles of either members of the media or to public figures. So she says that because that case doesn't read on this situation, it's not applicable. Under that case, the elements of standard defamation cause of action require the statement's false, it was communicated to someone else, intends to harm their reputation. That is standard defamation 101. However, in a landmark case called New York Times versus Sullivan, a very famous case, the United States Supreme Court adopted a new set of constitutional protections for publishers of information relevant to public discourse. Liable can claim no talismanic immunity from constitutional limitations. It must be measured by standards that satisfy the First Amendment. The general proposition that freedom of expression upon public questions is secured by the First Amendment has long been settled by our decisions. The constitutional protections do not turn upon truth, popularity, or social utility of the ideas and beliefs which were offered. Note here, it doesn't speak to facts. So whether ideas and beliefs are true is irrelevant. But as to facts, those have to be measured by standards that satisfy the First Amendment criteria. The Minnesota Supreme Court, in recognition of New York Times, went on to adopt holdings that are specific to Minnesota. So here's what Minnesota says. First, public officials and other public figures are subject to vigorous attack, including, under certain circumstances, defamatory and untruthful attack. Second, the privilege of defamatory attack is applicable to public figures even though such figures are not public officials. Third, the meaning of actual malice stated in the New York Times, although not fully articulated in a subsequent decision of the United States Supreme Court, has been given definition, at least in terms of what it's not. What the New York Times rule ultimately protects is defamatory falsehood. No matter how gross the untruth, the New York Times rule deprives a defamed public figure of any hope for legal redress without proof the lie was knowing or uttered in utter disregard. So yeah, that's the actual malice standard, right? You have to have proof, you have to have evidence the lie is knowing or recklessly disregards. In addition to Minnesota's adoption of the New York Times, reporting on statements made by law enforcement itself is specifically protected for journalists via fair report. Again, this isn't a journalist-specific thing, so I'm not sure why she keeps mentioning journalists, because it's not a journalist-specific thing. But fair report privilege is a privilege that applies. Fair report privilege is when you are reporting on government documents, government reports. So if a government report is defaming somebody, as long as you are fairly reporting on it, as long as you're characterizing it correctly, you can't be charged with defamation. So even if the report from the government is wrong, or even if it's lies for that matter, as long as you're reporting on it accurately, it's fair report privilege. Which is one of the reasons the lawsuit against John Oliver was such garbage, because everything he said came from a public document. The publication of defamatory matter concerning another in a report of an official action or proceeding, or of a meeting open to the public that deals with a matter of public concern, is privileged against claims of defamation if the report is accurate and complete or a fair abridgment of the occurrence. So as long as it's fair, you can't be charged for defamation for republishing. Similarly, Minnesota Court of Appeals stated, newspapers have a qualified privilege when making a fair, accurate report of public records. Again, that's not a newspaper-specific thing. While there may be some disagreement as to the application of the privilege to the Dr. Phil interview, the police report itself is a public record. So yeah, your ability to rely on the Dr. Phil reporting is one thing, but the police report itself is a government document you can rely on. Paulson's recitations of the complainant material are drawn almost wholly from the police report and the interview. So yeah, first of all, the police report itself is privileged, so you can't attack that, period. And secondly, to the extent you're relying on the Dr. Phil stuff, it's statements from her. So you can rely on those statements because she's there and she's offering what seems like a credible story. It'd be hard to get to negligence. The fact that Paulson repeats those items does not change the privilege, nor does it change the fact there were statements made by eyewitnesses whose account has a presumptive veracity. Yeah, that's exactly right. That's exactly right. Paulson's right. Like, yeah, you can rely on a government document. The police report's a government document. You can rely on that. And you have the woman herself saying, well, this is what happened to me. I mean, as long as she seems credible, and even, you certainly don't know it's false, and you wouldn't be recklessly disregarding it, particularly if they're on a show like Dr. Phil, where you presume Dr. Phil has also done some vetting. So maybe that provides a little bit additional reliance. So yeah, I think Paulson's right. Once again, someone may sue her one day with a cause of action that makes any sense. It's just not today. Actual malice for defamation purposes has been interpreted to mean a defendant acted with reckless disregard for truth or has a high degree of knowledge of the statement's probable falsity. Or you recklessly disregard. Motives of diminishing credibility do not establish malice. Yeah, this is one of the misfortunes of the term actual malice. Actual malice has nothing to do with motive. And the Supreme Court itself has said that. The United States Supreme Court has noted actual malice is a bit of an unfortunate, confusing term because it has nothing to do with bad motive or ill will. So yeah, the term actual malice has nothing to do with hatred or dislike or wanting to hurt somebody. It has a very technical understanding of what I say is malice to the truth, because that's kind of the only way it makes sense to me. Regarding similar intentional towards damaging a person, the United States Supreme Court has held a public figure may not recover for the tort of intentional infliction of emotional distress without showing the publication contains a false statement of fact, which was made with knowledge the statement was false or with reckless disregard. Nor can the fact the defendant published defamatory material in order to increase profits suffice. Reckless disregard cannot be fully encompassed into one infallible definition. We made it clear defendant must have made the false publication with a high degree of awareness of probable falsity or entertain serious doubts as to truth. Chrisley provided the precise opposite of that necessary proof, acknowledging that his daughter, Lindsay, had given the eyewitness account and police report to which Paulson was reporting was based, and that she told and has retold the story with consistency and a mobile party. The only proof rebutting Lindsay's story and Paulson's reporting thereon comes from a single baseless allegation uttered repeatedly through the complaint in different forms. Chrisley's account of the meeting is inaccurate. Well, maybe it's inaccurate, but it's her recollection, and you can't be negligent for merely reporting on it. There is nothing in the substance providing a single actionable allegation under the standards of the New York Times line of cases, and Minnesota's adoption thereof. Instead, Chrisley relies on a series of assertions that provide no proof and no basis for meeting the burden to show actual malice as defined in case law. For example, Chrisley relies on speculation as the basis for his allegations and then goes on to list some allegations about what he thinks, but doesn't actually provide any evidence of any of this, which is why he doesn't have a cause of action. Similarly, Chrisley complains repeatedly of Paulson's reporting on Lindsay Chrisley's victim statement, whether it was given to Dr. Phil or in the police report, without any explanation or allegations supporting the proposition that reporting on a witness's own statement is the basis for defamation. That would be really hard, because how could you be negligent for relying on that unless you knew that person had some sort of reputation for lack of honesty? In short, Chrisley's complaint is so devoid of substantive allegation it barely meets the standard for a run-of-the-mill defamation action. I agree with Katie Joy. It does, particularly because there is more than enough here to rely on. How do you even get to negligence? But even on the most favorable reading, it provides no basis for either overcoming constitutional protections for press, which I disagree, that's a separate thing, but whatever, or meeting the burden of proof in showing the existence of actual malice. So everyone, yeah, I think that this is yet another lawsuit against Katie Joy Paulson over here without a crystal ball that will not survive the light of day. Katie Joy Paulson has more than enough to rely on for what she said in her public reporting, and everything that Chrisley said is completely incompetent in the legal sense. So yeah, I don't expect this lawsuit to remain long for this world. Maybe someday someone will sue Katie Joy Paulson who actually has a cause of action, but it's not today. And at least, my friends, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.